So what is it that I am canvassing before your lordships? That there can be no hiatus. If there's a deputy speaker against you, we've given notice. The disqualification proceedings don't stop. That's my first bullet. At the outset, I made that submission to your lordship. They've not answered it. That's why the order of this court on the 27th, saying that, all right, you can file your reply, Malats, is as well as the proceedings won't go on. Is as if their proceedings won't go on. Because somebody else would have presided Malats over the house and proceeded with the disqualification. This is the problem with the Nabam Rebia judgment now.
So it gets referred.
And the deputy speaker cannot decide.
Until the decision of the committee of the house is taken, what happens in the interregnum?
Which decision of which committee?
This question as to his disqualification is referred to the committee.
Yes.
Right? Committee is looking into the matter. In the meanwhile, what happens?
No, the person elected as the speaker then, or chairing the house, will decide. There is no committee.
Read with 180.
Yes, there is no committee. So therefore, all this not dealt with in Nabam Rebia.
What's the ground for removal of this?
That's the other point I wanted. No ground. I'll show your lordship that notice. Nothing.
So that was not a disqualification. He was not being removed on disqualification under the 10th schedule.
Correct. Therefore, that notice was an ab initio void.
No, but they can always say that we don't have confidence in the speaker.
No, they can't, because that's the removal proceedings are under 179. I showed your lordship Shakhtar and call, which says it has to be for reason. I showed that to your lordships at the outset. Because removal is stigma, which is why he is allowed to be in the house, allowed to participate in the proceedings and respond to the allegations. It's not a no confidence. No confidence is no reasons. It's a removal. Again, not considered in Nabam. So these are very serious questions. That's another broad point I wanted to make, before I proceed. Their claim is not that there is a split, but that they represent the Shiv Sena. That's their case, which has been decided by the Election Commission in their favor, that there is no distinction between the legislative party and the political party, and the 10th schedule does not stifle the right of the legislatures to dissent. That's their argument. And it's not that he cannot call for a floor test, but the reasons on the basis of which he must call for a floor test must not be extraneous and irrelevant, which is what I tried to show yesterday to your lordships. That 34 of them have come to me and I recognize them. That's the decision of the governor. If that's germane to his decision-making, constitutionally germane to his decision-making process, he's right. And that's why I said to your lordships yesterday, and I gave your lordships the Sarkaria Commission, that the governor can only deal with alliances. He can only deal with parties. He cannot deal with individuals. Otherwise, there'll be havoc. Any 3 people from any party will go to say that now you must call for a floor test. Moreover, only 8 out of 32 members were ministers of the government. The rest were not ministers. So how could he say they want to move out of government? Only 8 of them. So on what constitutional basis can the governor recognize, whether minority or majority, a faction in the legislative party to direct a floor test? My lord asked me a question related to this. Paragraph 3 said not less than 1/3. It could be 75%. So it envisaged a situation where the majority would go away, a minimum being 1/3, and gave that protection. After it was deleted, neither 1/3 nor 75 will get protection. That's the consequence. So one thing is quite clear, that the paragraph 3 dealt with factions. An argument to say that I am the party is contrary to the constitutional framework, because he is not the party. Because the party is registered under section 29A of the Representation of People's Act. The office bearers of the party are communicated to the Election Commission. And the Constitution as accepted is the final document. He can't now say I am the party, because the party with the Election Commission and the party with the speaker is only the members of the legislature belonging to that political party. So you can't say I'm the party. So that proposition is unfounded in constitutional law. And your lordships have now read all the documents. Till July the 4th, is there any reference to any split? No reference. No mention of split. Why? There's a constitutional basis for that also. I tell you just why. When I seek election directly from the electorate, I don't seek election in my personal capacity. I seek election on the symbol of the party. In my activity in the house and outside the house, I continue to be a member of that party and must honor the discipline that's imposed on me. So in the relationship between the legislature and the political party has primacy. The legislature party has not primacy. So when you are interpreting the constitution, you have to give primacy to that political party whose representative I am in the legislature. You can't in the process give primacy to the legislature over the political party, which the other side is trying to do by saying, I am the party. It can be one member of legislature, but can he say I am the party? So within the constitutional framework, the will of the legislators in fact is subject to the functioning of the political party both inside and outside the house. Now he can have dissent outside the house, but no dissent within the house, which is why the whip. Because there he represents. That's why Holohon says you can't go against it. That's the rationale for it. Well, it's constitutional rationale for it. Parliamentary democracy only recognizes alliances between political parties, and not an alliance between a political party and a faction of a legislature party. That'd be constitutional harakiri. There is no space for factions when the governor has to appoint a chief minister. Now, if all of Shiv Sena had gone to the BJP, governor will call for a floor test. If the Shiv Sena itself had gone. Now, this is cast in stone. Now an argument is being raised, it doesn't matter, and which is why, I said to your lordship the consequences of it. Supposing 2 or 3 members of each political party who don't form the majority go to the governor and say that support of 6 of these people reduces the chief minister to a minority, therefore call for a floor test. It would be disastrous for democracy. That's the Airam Gayavaram principle that we gave up. Would 50 members of BJP today support Uddhav Thackerey, will he call for a test? So, the whole propositions, the propositions that have been advanced by learned friends are all contrary to basic principles of constitutional law. Hence, from the very initiation of the election process, the identity of a candidate for an election is as a representative of the political party by which it was set up. So the primacy is of the party. The legislature has no identity other than being a representative of the party. So he should have assumed that they continue to be in the Shiv Sena, and that Shiv Sena had 52 members, and all the 3 parties together have 152 out of a house of 280. There was no occasion for him to say have a floor test. He knows, because he is not a member of the assembly, but he is part of the legislature. So he knows. So he went outside the scheme of the 10th schedule as well as the scheme of the constitution to recognize a faction. Majority or minority doesn't matter.
According to you, suppose there is a split, which is now, of course, not recognized.
Yes.
So what would have been a split under the unamended provisions of the 10th schedule? But there is a group of legislators who have otherwise left they say we have withdrawn support.
Correct.
Right? Whether they withdrew support here or not, that you already made your point. Now, they will incur a disqualification because there is no split which is recognized by the 10th schedule now.
Yes.
Can the governor not then look at the numbers and say that, assuming that these people say that we have left, whether they incur a disqualification will be decided by the speaker, but this conduct of these people in doing something which is contrary to the 10th schedule also is liable to affect the strength of the house and the strength of the number of parties in that house, or the strength of the party in that house. Can he not do that?
No.
Because your argument is he can't do that at all.
No, forget the majority. This can happen where 2 or 3 or 4 members of each political party can do the same. What you're doing is, when there was no 10th schedule, what used to happen? The same thing. What my lord is putting to me used to happen when the 10th schedule was not there.
Right.
So you are going back to a state where the 10th schedule is not there. That's my answer. Because that's exactly what your lordships are putting to me. Can't the governor, looking at the fact that these people now say they want to withdraw support, they may be disqualified as a separate issue.
Then your submission would be that the governor can't call for a trust vote in oblivious to the provisions of the 10th schedule.
No, forget the 10th schedule. He can't call for a trust vote, by recognizing a faction in a political party which has no identity, which has no constitutional identity. That's my submission. Your lordships are now looking at them as a group. They are not a group, they are individuals. There is no concept of a group within the legislature. Each is an individual. And government formation is based only on alliances. And therefore, calling a trust vote has to be based also on alliances if it's been reduced to a minority. That's accepted now by Rameshwar Prasad. They could have followed the Madhya Pradesh model, resigned. No, they wanted to be chief ministers and posts, so naturally, they could have followed the other model. That also is a constitutional issue which one day your lordships will decide. That's also another issue. The collective decision to resign as a group, well, it is something which is very suspect in constitutional law. Suddenly, all of them together one day decide we all must resign.
This is in line with Quixote, unless we question Quixote.
Well, I have always questioned it. I have always questioned it, but that's another issue, Malaj.
But it also has a bearing on coalition governments,
Yes.
particularly regional parties.
Yes.
Regional parties, this argument could sometimes be very dangerous also, because there is absolutely no freedom in the party except for one leader. Many a times it's a family which runs it, and there is no scope of anybody else coming into the fray
In fact,
and setting up an alternative, because it's impossible. Virtually, we are interpreting the constitution to say that it is just not possible for any legislator.
Malaj, in fact, this has been my grievance. What happens, Malaj, in the United States and in the UK, Malaj, a president, Malaj, of the Republican Party will reach out to Democrats to get a bill passed. The insurance, actually, Barack Obama had to reach out to the Republicans for his insurance bill. And in the UK, the same thing, the Conservative Party or the Labour Party reaches out to the opposition members. There is no such thing as defection. This is the problem. But anyway, Malaj, we are in another era. At the moment, we are on the law as it stands today. So we go back to the Gairam regime, where there is no 10th schedule, and you can actually move the governor for toppling any government you want at any time you want. Yeah, a few people. Malaj, there is an NCP case where only four people of the NCP, Malaj, actually went away. There were only 4 members, all of them went away. So it can happen.
So according to, going back to the Sarkaria Commission report, which was relied upon in Rameshwar Prasad, this was a post-electoral coalition of parties.
That's correct.
Of course, with the support of some independents as well.
Yes.
So according to it is only if any one member of the alliance and
Shifts.
or one member of the coalition shifts,
That's right.
that the governor can then say that, look, as a result of one party in the coalition, one member of the coalition having shifted,
Correct.
or ceased to back the government. Therefore, I feel now your vote in your confidence in the House,
Yeah.
the confidence of the House in your government is now liable to be affected. Therefore, I call for a trust vote.
Therefore, he is not concerned with the 10th schedule at all, Malaj.
Right.
With the greatest respect.
Right.
Governor is not concerned with it. That's a separate proceeding. Whether they'll be disqualified, they may not be disqualified. If they vote against the whip, Malaj, within 15 days, I can condone it. Or if you have sent notices to 16, the others may say, now I don't want to lose my membership. They will come back. That arithmetic and that, Malaj, the consequences are not relevant as far as the governor is concerned, or even the court is concerned. Court is to judge the act of the governor on the 28th of June, Malaj, whether that was right or it was wrong. And I might say this to your lordships, Malaj. Malaj, when we enter this courtroom, Malaj, we are in a different aura. We come with hope, with the expectation that you are the only hope in this country. Power. Well, if you look at the history of civilization, all injustices are based on power. Whether it was the execution of Socrates, why was he executed? He was executed because he didn't believe in the Athenian gods. He was executed. The same thing is happening today. Not in that sense. Where do we go? Therefore, Malaj, this court's history has been so phenomenal, and your footprint is the largest around the world. You are the beacon, the hope of 1.4 billion people. And you can't let democracy be destabilized in this callous, uncouth fashion. I'm sorry, Malaj.
But then taking your argument to its logical conclusion, that means that the governor cannot really have regard to any individual movement of a group or a number of MLAs
Yes.
or MPs.
That's Bomai, Malaj. Exactly. Para 88 of Bomai
Their
says that.
movement lies within the province of the speaker
Yes.
under the 10th schedule.
Internal dispute he can't deal with. Para 88 of Bomai, Malaj. Intra-party disputes he can't deal with. The proper cause for testing the strength of the ministry is holding the test on the floor of the House, because the Chief Minister said, I am ready to hold that test. And Para 3 was there on that day of the 10th schedule. And Malaj, what did the governor do? 356. It's in that context that Bomai says, which is why I said the other day, these decisions are contextual. There's no general principle that can be applied across the board. There can't be. Freedom of speech is a general principle. How you will actually, Malaj, recognize it is the context. So first you must reach a bona fide, constitutionally valid conclusion that this requires a floor test and on relevant considerations. If you are able to justify that to the court, then the only remedy is the floor test. You are now looking at an intra-party dispute. They have come to you, they are 34, I recognize you, I recognize the leader because he is the leader. And this intra-party quotation is from Sarkari Amalats. It is adopted by Bomai. And it is consistent with those propositions, Malats, that I read to your lordships of Sarkari Amalats adopted by Rameshwar Prasad. So you can't enter into moment you say, okay, I'll recognize these three people, I will entertain these two people, and then now you have lost majority, now you have a floor test. Impermissible. That's the old non-10th schedule regime, the Ayagram, Gayaram regime. Well, that's actually, I must give credit to my colleagues.
Yes.
Well, that's Mr. Tiwari, Mr. Devdutt, how wonderfully they have prepared this case. Extraordinary. And I owe gratitude, sense of gratitude to them.